And welcome to the DADS Television Network. Another hour for you. This hour we're going to talk about child support, the guidelines. All you guys know about that stuff out there. I know a little bit about it, but I thought I would invite two attorneys to help me and to help you understand. Now, during the program, we'll probably flash that number on the screen. If you see the number flashed on the screen, please feel free to call in and ask these guys questions. If you do not see the number on the screen, that means you are watching a tape. It is not live. To my right, Greg Austin. Greg Austin is an attorney in Oregon, primarily in Portland. If you'd like to get a hold of him sometime, let me give you his number. That's 222-6102. Among the things that he is proficient in is domestic relations law and the child support guidelines. Now, to my left is Vic DeFlemick. Now, Vic DeFlemick practices law in the state of Washington, and he's located in Vancouver, and I cannot remember the Vancouver number or the Portland number. He's got two numbers, and Vic, what are those numbers?
The Vancouver number is area code 360-750-5572. Portland line is 283...
281-3588? Is it 281-3588?
Yeah, 286-3588. That's 286-35. I never call it. I can't think of it.
Okay, right. Well, I call that one.
503
okay.
number.
So what we're going to do, guys, we're going to talk about the child support guidelines. Now, we do this from time to time. We talk about custody, visitation, and child support. All right? Now, a while back, I attended some meetings, or a meeting. It dealt with the state of Oregon and child support, where the agency itself, Support Enforcement, had a discussion about some of the bills coming through and administrative procedures. Now, if we're ready, I'd like the control room to roll the tape on a discussion from Larry Thompson, who is in charge of Support Enforcement, talking about administrative procedures. Roll tape.
But my view of the administrative decision-making process is, I don't want to use the term rough justice too roughly, but it handles the high-volume work and is accurate most of the time, works for most of the people, and is cost-effective, efficient, and those are your priorities. In the extraordinary cases, it probably doesn't work for, and they need to be decided in a court or some other process. If you give preclusive effect to the decisions of these hearings officers, they will feel, and their lawyers will feel obliged to make more of a record and complete matters, more discovery, this kind of thing at this level, and basically change that process. It's no longer, it's a mixed process. It's no longer the quick one. So it'll be one kind of hearing for people that are represented or sophisticated, it'll be another kind of hearing for those that are not. The hearing officers themselves will have a different view of their role because sophisticated folks are getting one form of dinner and the other folks are not. They'll want to try and, hey, this should be evenly applied. So in the unrepresented cases, they will start doing more discovery on their own. It's more of an inquisitorial process, feeling a duty to make more of a record. And I would rather have it that the judges bifurcated on their end. Some of them are more fond of our process than others, and will send the case back and let us do the support type work than to do it this way, where some judges are quite comfortable with it and others are not. My other philosophical point is the state of Oregon has something that I don't think you'll find in any other state in what's been delegated to its administrative process. Everything from sophisticated civil penalties to modifying judicial decrees. If the bench and the bar don't buy off on that, we set up a domino effect of losing not just little pieces where they're unhappy, but it sort of starts to roll and you lose it all, maybe even to issues of separation of powers and the appropriate allocation of functions. In fact, in the latest Administrative Law Journal out of the American Bar Association, there's a big discussion of Judge Scalia's role of separation of powers. we would not be having child support hearing officers under Judge Scalia's view of the world as a constitutional matter. So my inclination is to protect, I hate to say as long as we can, as these things do move in cycles, but to protect the administrative process in its current version. And I think that this approach, well-intentioned and it's a philosophical discussion, and maybe, and I could be just flat wrong on the facts and the practical effect, but half of the judges don't want any administrative hearing officer precluding some decision of theirs. The other half might be quite comfortable with that. Thank you. And ominously enough, guess what happened just within the last month? The House of Representatives has abolished the hearings function in the Department of Revenue, transferred en masse all those hearing officers to the tax court, created a new function, judicial function, tax magistrate, and we don't have administrative hearings in the Department of Revenue anymore. That's true.
Okay, what that was all about, in case you didn't understand, of course he was talking about administrative law process, where the Office of Support Enforcement sometimes calls you guys in or calls you over the telephone. You have what is called a telephone hearing. The agency or the agent that represents the agency goes over the guidelines, goes over the rules, looks up your income on a table, the number of children that you have, and then figures your child support based on a set of tables and the rules. Now, Greg Austin is here to help us with that. Again, if you have any questions on that, please feel free to call in and to ask questions. The first thing I'm going to do is just ask something general. Now, you may have some specific questions. Greg, what about these guidelines? First off, you've heard about them, no doubt. You've seen them, you've read them, you read the rules. Are they fair? Are they necessary? Just a general statement about the guidelines.
Well, I think you have to really see them in their historical context to get an honest answer to that. The guidelines exist because the federal government 5 years ago said that any state that did not implement guidelines would lose their federal welfare money, their aid for dependent children. So all of these guidelines in all of the states were implemented as a federal mandate, and the people behind that were the people who were distributing aid for dependent children, welfare money.
Sure.
So these guidelines really are intended to enable the state to recapture welfare money.
Okay.
And in the context of welfare recipients and their children and their absentee spouses, they may make a lot of sense. From my perspective, they make a lot less sense when the idea of capturing that tax collection process, if you will, and applying it to people who aren't in a tax collection mode,
Gotcha.
I think begins to break down. So,
Well, what about, okay, I think you spelled it out very specifically, precisely, and concisely for welfare repayment to the state. So that brings up the other side of the coin. What about, Greg, non-welfare cases? Why would there be guidelines then for those who have spouses that are not on welfare? Why would they apply?
I think there are two reasons. The first is that in order to legitimize guidelines for welfare parents, then the guidelines have to apply
To all.
across the board.
Okay.
And a second reason, and probably a better one, is that there's a goal of judicial economy, if you will. I mean, the courts are bogged down. Everybody knows the courts are bogged down, and they, in fact, are bogged down. So if we can reduce some of the things that people argue about in court to a formula, to a grid, to walking across and throwing a dart at a box on a piece of paper, then to that extent there's a lot less work
Okay.
thrown at the courts.
Do you have, now I'm gonna turn my attention to the Washington side of the river here, and Vic DeFlemick. And I wonder, Vic, do you have any different take on the...
Well, I think I'd add a little bit to that, in that I think that what the purpose of the child support guidelines, adding to what Greg has said, it brings some uniformity to that process, and it's not just judicial economy, but I think it's the economy as it affects the people involved too, because it takes a lot of the emotion out of the child support setting process. It makes it more of a numbers game, and you know, as everybody knows, going through court is a long, tedious, expensive, traumatic process, and anything that you can take away from that to reduce it to a numbers game makes the divorce or child support process
a lot simpler?
a little less traumatic for people.
All right, let me play the devil's advocate for either one who wants to take this on. Suppose I say, and I want you to listen to this too, those of you watching, why should there be guidelines which are structured as we have seen, and maybe we can get a camera in on this. I don't know whether we can get a camera to pick this up or not. Can we get one of the cameras, maybe number 2, to pick this up? Why do we need a set of guidelines which are, should we go which way? Right there, okay. Come right on in on it, number 2. Why do we need a set of guidelines which are so complicated? Across the top, we can see family sizes across the top. We can see incomes down the side. Why does it have to be that complicated? Why can it not be simple? And let me offer a suggestion. The state pays out so much money in foster care, real simple number, a foster care dollar. And so just on the principle here, guys, and I know that neither one of these guys are legislators. They don't know why the legislature does what it does, and this is not their doing. But I thought I would ask, why wouldn't it be simple enough just to say, well, if the state pays out X number of dollars for foster care, why not make that the guideline level, and anyone who wants to pay more, hey, have at it. Any comments, guys?
Yeah, I think you need to keep in mind that when the state is paying out welfare foster care dollars, they're paying out the state's dollars. And that's not the same thing as when the state is mandating the dollars that you and I should pay.
Okay, you got anything, Vic?
Well, I don't think I really have anything to add to that, I guess.
Okay. We're going to get into the guidelines themselves now. We're going to talk about numbers and figures. We're going to talk about some of the rules. And as we have compared notes, and perhaps you know, guys in Oregon may make out a little better on the numbers than guys in Washington, and maybe there's a reason for that. We've got a little more footage to run, and what I'd like to do is run a little footage that has to do with fathers, young fathers, those who may be teenage or in their early 20s, and how the system sets up in the first place. It's designed to capture these young guys and put them into the system right off the bat. And during the discussion, I raised the question, and perhaps we can see that in this particular footage.